Hello and welcome to the Minimum Competence episode for Thursday, April 24th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, the CFPB is backing off of PayPal, Trump suing Perkins Coie, firms fighting his executive orders, and California's bar exam fallout. Let's remember, compassion is the basis of morality, and read today's legal news. On this day in legal history, April 24th, 1916, the Easter Rising erupted in Dublin as Irish Republicans launched a bold and ultimately tragic insurrection against British rule. The event, intended to establish an independent Irish republic, had enormous legal and constitutional consequences that would ripple through British and Irish law for years. Roughly 1,200 rebels seized key buildings across Dublin, proclaiming the establishment of the Irish Republic from the steps of the General Post Office. In response, the British government declared martial law and deployed thousands of troops to suppress the rebellion. Courts martial were swiftly convened, and between May 3rd and May 12th, 15 rebel leaders were executed, including Patrick Pearse, James Connolly, and Thomas Clarke. These summary executions, carried out without the protections of civilian trial, shocked many in Ireland and Britain and were later criticized as legally excessive and politically tone-deaf. The use of military tribunals rather than civilian courts raised serious questions about the limits of legal authority during wartime and the rights of those accused of political violence. The Rising also marked a critical turning point in British colonial legal practice, highlighting the inherent tension between empire and constitutional rule. In the wake of the rebellion, the British government passed additional emergency laws to manage dissent in Ireland, but these legal measures only deepened nationalist sentiment. The Easter Rising set the stage for the Irish War of Independence, the 1921 Anglo-Irish Treaty, and ultimately the creation of the Irish Free State in 1922. The legal legacy of April 24th is one of sharp contrast between the rigid imposition of imperial law and the revolutionary demand for self-determination. It remains a powerful example of how law can be both a tool of control and a symbol of contested legitimacy. The Consumer Financial Protection Bureau, or CFPB, has agreed to drop its appeal in a long-standing legal battle with PayPal over a 2019 rule that required digital wallet providers to disclose fees using a standardized form originally intended for prepaid cards. The decision came through a joint filing on April 21st in the U.S. Court of Appeals for the D.C. Circuit following a March 2024 district court ruling in PayPal's favor that limited the reach of the rule. The CFPB's regulation extended fee disclosure mandates for prepaid cards to digital wallets, despite the agency's own acknowledgement that most digital wallets don't charge such fees. PayPal contested the rule soon after its issuance, arguing that digital wallets function differently from prepaid cards since they store payment credentials rather than actual funds. In contrast, prepaid cards are used to store and spend cash directly. The legal journey began when Judge Richard J. Leon initially sided with PayPal in 2020, but his ruling was overturned by the D.C. Circuit in 2023, prompting a remand. Leon again ruled for PayPal in March of 2024, leading the CFPB to appeal before ultimately deciding to drop the case. This withdrawal marks the second recent instance of the CFPB, under Acting Director Russell Vogt, stepping back from litigation challenging its rules. A week prior, the agency also agreed to halt enforcement of a proposed $8 cap on credit card late fees amid a separate lawsuit. PayPal is represented by Wilmer Hale, which, you will of course remember, has been targeted by a Trump executive order. President Trump announced via Truth Social, because that's normal, that he is suing the law firm Perkins Coie, accusing it of committing egregious and unlawful acts, specifically pointing to the actions of an unnamed individual at the firm. However, it remains unclear whether Trump intends to file a new lawsuit or was referring to ongoing legal disputes. Last month, Trump signed an executive order that aimed to terminate federal contracts with clients of Perkins Coie if the firm had performed any work on them. In response, Perkins Coie sued the administration, claiming the order was unconstitutional. Trump's legal team also requested the recusal of U.S. District Judge Beryl Howell from overseeing that case, alleging a, quote, pattern of hostility toward the president. Trump repeated his criticism of Judge Howell in his latest post, calling her highly biased. The legal conflict adds to Trump's ongoing confrontations with the judiciary and firms linked to Democratic causes. Perkins Coie has historically represented Democratic interests, making the dispute politically charged. Law firms, including the aforementioned Perkins Coie and Wilmer Hale, asked federal judges in Washington, D.C. to permanently block executive orders issued by President Donald Trump. The firms argue the orders are unconstitutional acts of political retaliation. These orders sought to revoke government contracts held by their clients and restrict the firm's access to federal buildings, citing their ties to Trump's legal and political opponents. The legal battle marks a significant escalation between major law firms and the Trump administration. U.S. District Judge Beryl Howell heard Perkins Coie's request for summary judgment, while Judge Richard Leon handled Wilmer Hale's case later in the day. Both judges had already issued temporary blocks on Trump's orders in March. The Department of Justice defended the executive orders as valid exercises of presidential authority. Meanwhile, other prominent firms like Paul Weiss and Skadden Arps have settled with the White House to avoid similar orders, agreeing to provide pro bono services and other terms reportedly totaling nearly $1 billion in value. The legal community has widely condemned the executive orders. Hundreds of firms and legal organizations argue the moves were designed to chill legal representation against Trump, infringing on the right to counsel and undermining the legal profession's independence. Some attorneys at firms that settled have resigned in protest. The State Bar of California plans to ask the California Supreme Court to lower the passing score for the February 2025 bar exam after a troubled rollout that included technical and logistical failures. The proposed score of 534 is below the 560 recommended by the bar's testing expert. This score adjustment would apply to all test takers, regardless of the specific issues that they individually face. February's exam marked the first time California administered a hybrid bar test offered both remotely and in person, and without components of the long-used national bar exam. Although the change aimed to reduce costs, it resulted in significant problems such as software crashes and intrusive proctoring interruptions. It's unclear how many of the 4,300 examinees were affected, but the state bar has opened an investigation into the widespread issues. The bar also recommended imputing scores for test takers unable to complete key sections, a process that estimates performance based on completed answers. The Committee of Bar Examiners acknowledged the challenge of crafting a remedy that is both fair and preserves the integrity of the underlying exam. In addition to adjusting scores, the committee is considering provisional licensing programs that would allow affected test takers to practice under supervision while awaiting full licensure. Final test results are due May 2nd, and the Supreme Court is expected to rule on the score change request by April 28th. The committee will meet again on May 5th to consider further options. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. If you have a moment and can leave a rating or review on your podcast player, we'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, mostly it is loss which teaches us about the worth of things.